Welcome back to the channel. In this video I'm talking about how to win an argument, and specifically how a barrister might go about winning an argument, because an argument to be won is by design. It needs to be well constructed. It doesn't happen by accident. It isn't just put out any of your thoughts randomly and hope to win the argument. That simply doesn't happen. So let's start right at the beginning. You have to decide what it is that you're trying to prove, because if you don't know what you're trying to prove, then you might end up going round in circles. Because if you have one overriding point that you wish to make and to prove, let's say this is in court and you're trying to get a decision in your favor, then you need to know what that overall decision and overall argument is. And the reason for that is because you need to know how to make up that argument to prove or disprove this argument, let's say if you're in court. Taking the example of theft, for example, if your argument is that you want to prove that somebody stole something, then you have to prove each of the elements of the offense. So this is how I'm going to break down the discussion of this argument here. So let's say you're the prosecutor and you're trying to prove that someone is guilty of theft. There are 5 elements to theft. It's the dishonest appropriation of property belonging to another with the intention of permanently depriving that other person of it. Now you as the prosecutor will have to prove each one of these elements of the offense, and without any one of which you will not have made out the offense and you will not win the overall argument. Let's say, for example, it wasn't dishonest appropriation. Let's say that the person believed or had reasonable grounds to believe that they had permission to take this item and use it for a period of time. Then not only did they not appropriate it dishonestly, but they may not have appropriated it with the intention of permanently depriving the other person of it if they intended to return it. So again, if you can't prove each and every one of these points, you're not going to win the overall argument. So coming back to the point, you need to decide what it is that you need to prove, and then you need to plan how it is you're going to prove it. The next point is, it doesn't necessarily matter what you believe. Let's say you are now the defense barrister and you've been given a set of facts to defend this defendant by your instructing solicitor. Let's say that you think that this set of facts and this excuse or defense, if you will, is a bit far-fetched and you don't quite believe it. You may have given advice to the effect of the strength of the evidence against the defendant and the fact that this defense is a little bit far-fetched and unlikely to succeed. But then let's say that the defendant says, absolutely no way, I am not guilty of this, and your solicitor tells you that these are the instructions and this is how you are to present the case. Then it doesn't matter what you believe. Contrary to popular opinion, if a defendant tells you categorically they didn't do it, your advice to that client must be that they plead not guilty because they've told you that they didn't do it. Many people misunderstand the point that if there is strong evidence against the defendant that you must advise them to plead guilty. This is absolutely wrong and a fundamental mistake of many law students. Indeed, if there is overwhelming evidence against them and you believe they will get convicted, it is your duty to advise them that they would get a reduction in sentence for an early guilty plea. But if they maintain that they are not guilty and they didn't commit this offence, then your duty is to advise them not guilty. But anyway, the point is, if you find that this is a very far-fetched defence, you as the barrister may well make strong representations to this defendant that you don't believe his defence is going to work. But at the end of the day, it doesn't matter whether you actually believe this set of facts given to you as the truth by your defendant or not. In fact, the only times opinions really count is, first of all, if they are given by a victim and they are saying that in their opinion they were really frightened by the events, because that might be relevant to the offence at hand. Or otherwise it might be an expert opinion, that might be a medical opinion, or it might be of someone who has particular experience in a certain line of work for a very long time. For example, if someone were to come to me asking me to be an expert witness in a case where a martial artist was accused of going over the top in his self-defense, I would expect the court to be able to deal with that in most cases. But if they came to me, I am an expert because I've trained in martial arts for over 30 years now. So over 30 years of training and being a 6th degree black belt makes me an expert in that particular field, and I could stand as an expert witness in cases like that. The only other time opinions are really counted for anything are things like infant settlement hearings, because parties cannot agree a settlement involving a child unless they've had counsel's opinion before the court and the judge accepts it and makes a ruling as to what the appropriate level of damages is. But otherwise, and very broadly speaking, opinions don't count. And as a more overarching point, your opinions are not really going to advance your arguments any further unless, as I said, it's supported by any of these expert opinions and you are essentially just taking that as your own and repeating it. But really, that's an expert opinion, not yours. So now think about constructing the argument itself. As I said, you need to take each individual individual point, which, if proven, then taken together, can prove your overall point, much like the 5 elements of the offence of theft. One of the ways you can do this is by taking precedent, previous decisions of a court. For example, a butter knife has been held to be a bladed article for the purposes of Section 139 of the Criminal Justice Act 1988, and yet a screwdriver was taken not to be a pointed article. So the offence would be slightly different perhaps. It may be considered an offensive weapon if they've been carrying it for the purposes of self-defence. But if that's not the offence with which they are charged, then that's one of the points you can make, as I said, supported by authoritative decision. Other ways of proving these points might be an objective argument, which might come about by the way of a study or certain data or polls. If you get enough people or an authoritative study that says this many people were surveyed and 95% said they agree with it or disagree with it, then this again can go towards proving one of these points for you, and then again, taken together, can win your overall argument. Then using those in an example, let's take an example, random example of CCTV evidence. Let's say I'm trying to disprove that something happened or just challenge the evidence of something because the sole piece of evidence is CCTV footage capturing this defendant in this alleged offence. CCTV is one of the notoriously broken down elements in cross-examination because somehow most of us these days carry around a 4K camera, very high resolution, that can take a photograph and video at a moment's notice. And yet for some reason when it comes to CCTV, the images are all quite small, pixelated, maybe even only one image every 3 or 4 or 5 seconds, maybe not actually capturing the moment in question, but literally the few moments either side. One potential line of cross-examination regarding CCTV might be as follows. It's right, isn't it, that this CCTV monitor is very small, only 12 inches wide? Yes, it is. It's also correct that this is a black and white image rather than full colour. That's right, isn't it? Well, yes, it is. It's also right that it only takes one still image every 5 seconds. That's also true, isn't it? Yes, indeed it is. It's also true that it was raining on the evening in question, meaning that the image wasn't entirely clear as it could have been. That's right, isn't it? Well, yes, that's true as well. It's also true that this is not a high-definition camera. That's also true, isn't it? Well, yes, it is. Then taking all those points together, it is also true that you cannot say with any degree of certainty that this man appearing in the CCTV image is this defendant. That's right, isn't it? And then when you take all of the original points taken together, all of which have a logical conclusion to the final question, it is then difficult for someone to challenge that and say, actually, no, it is a crystal clear image that you can see very clearly, making sure it's this defendant. Because of course they're not likely to agree with you with the final question, but with all of the previous questions which you've stacked in your favour, make it much more likely that anyone else listening to this cross-examination is going to find in favour of your arguments. So I hope that's an interesting overview of how you might approach certain arguments. Please like the video and subscribe, and I'll see you next time.